Okay, the next item I have on the chairman's report is there has been some discussions about drug court between DHS and the district attorney and the judge, and DHS is afraid that if we don't get things improved, we're not going to get the funding from the state the next time around, that basically drug court is failing. So I asked each one of them to be here to provide their side to us of what they see and what they think is missing, and then it'll be up to us to decide how we're going to proceed. I guess we'll start one at a time, and why don't you come up? Becky, I believe, is here for Health and Human Services.
I'm Becky Edgren. I'm the Drug Treatment Court Coordinator for Shawano County. The DHS board had asked me to come to the meeting today to give a background regarding the drug court program for those of you who are newer to the county board, just to give you a little information about what drug court is and then how it got brought to Shawano County. And then also we'll talk a little bit about the successes of our program so far, and then just some of a couple concerns that have been brought up. So, there was a formal resolution that was drafted and unanimously passed at all committee and board meetings, with the final county board decision being made in August of 2017 in support of developing a county adult drug treatment court program. The adult drug court program was selected by the Shawano County Board due to the presentations provided, which show the cost savings and overall excellent outcome that's proven by research, showing drug courts to be more effective than an offender just sitting out their sentence in jail. Through the adult drug court, participants receive lengthy treatment programming and intensive case management services that help them to stay sober and to build productive lives for themselves and their families. But they also are held accountable by a judge to review their progress throughout the program at least every 2 weeks. They're seen before one of our judges, and then they receive rewards for doing well and sanctions for not living up to what the obligations are that they've agreed to with joining our program. The National Association of Drug Court Professionals states that research has proven that drug courts work better than jail or prison. They work better than probation and better than treatment alone. Drug courts significantly reduce drug use and crime and do it cheaper than any other system, any other justice strategy that's used with these people. So adult drug courts are built around the premise of a specific target population. You can't just accept anybody into the program because it's not going to work for everybody. The target population is high-risk, high-need offenders, and that's been proven by national research done over the past 30 plus years regarding drug courts. The research has proven that without the intensive treatment and programming, nothing will change with these offenders, and the cycle of recidivism is going to continue with them. So high-risk individuals are those individuals who have already failed at jail or probation, most likely continue to commit crimes related to their drug problems. High need means that they've been diagnosed with a moderate to severe substance use disorder. So that means that we're not enrolling those who are dealing drugs to make a living or a profit off from it, but those who are actually drug dependent and in need of treatment. Low risk or low need individuals are successful with just probation alone or treatment alone, which is one reason why they're not the appropriate population to refer to drug court. Some things that we know about drug courts. Drug courts are the most effective strategy for combating methamphetamine addiction and work better than treatment alone. That's a huge problem in our county, methamphetamine addiction. Imprisonment has little effect on drug abuse. Research has proven that drug court's effects on crime can last for years, if not decades, which in turn affects the money spent in housing offenders in jail or prison. Drug courts save taxpayers considerable money. So studies have shown that the average cost savings ranging from more than $4,000 to more than $12,000 per client. These cost savings are due in part to reduced jail or prison costs, reduced revolving door arrests and trials, and reduced victimization. For every federal dollar invested in drug court, $4.30 is leveraged in state funding. So in Shawano County, the DHS levy dollars that were saved from our TAD grant that we received in 2020 alone was $37,325. And the program has had an estimated savings in incarceration costs of over $210,000 since starting it in 2018, with like jail costs for keeping the people there instead of bringing them into our program and having them go through treatment and the intensive case management. If filled to the capacity of 20, it could have saved $401,500 in jail costs in 2020 alone. Our county will continue, well, if it were that we lost the grant, our county would have to continue funding the drug court program without that grant money if that were decided by the board to keep it on if we lose the grant. So currently we have 8 participants enrolled in our program, and our capacity is currently 20 participants according to the grant. Since the program began in October of 2018, there have been 55 referrals, 15 enrollments, and 6 terminations of those 15 enrollments. We had 31 referrals in 2019 with 7 enrolling. In 2020, we had 13 total referrals to the drug court program, 5 of which were from probation. We've received 1 referral over the past 4 months, and that was an ATR referral from probation. And then our last referral prior to that was received in October. So currently we have no referrals waiting to be screened in. The best practice states that all cases meeting minimum eligibility requirements should be screened for risk need levels and substance use disorder diagnoses, and then the team determines acceptance into the program based on the results of this clinical screening that's done. And then also, so it's based on the results of the clinical screenings done and the legal screenings done by the DA and law enforcement. Minimum criteria to get that person to the screening process is they need to be a Shawano County resident, they need to be available for adult jurisdiction, and they must meet the requirements, the minimum level of charges drug related to be eligible for the program. Through the current process, new cases not referred by probation have to be approved by the DA's office prior to even reaching me for that screening process. So that's a little bit of the concern that was brought up by the Department of Justice in relation to the grant. That's who oversees the grant that we receive, is the Department of Justice. And the program manager and I spoke, and she said that if things don't change with our referral numbers, our admissions, and having the proper kinds of admissions, the high risk, high need admissions into the program, they can't continue to justify giving our program money, and we'll lose about $107,000 in TAD grant that's used to operate the program every year. We did not use almost half of our grant funds for 2020, partially due to not getting the referrals and admissions needed to expend those grant dollars last year. So we kind of lacked there. And that was kind of the concern with the TAD grants program manager. Current program successes that I'd like to share with the team or with the group here is that we had our first drug court graduation that took place on September 1st. This individual remains an active mentor in our program now, and he's trained as a peer support specialist and recovery coach. We have 2 more participants who are within 1 and 3 months of graduating, one of which is also a trained recovery coach. 2 participants are working full-time at Saputo Cheese, making $20+ an hour, both of which were unemployed prior to joining our program and had heavy drug addiction issues. 5 are working part-time to full-time hours in local Shawano businesses. 1 is currently at residential treatment who just joined our program, and that's funded solely by the drug court TAB grant. 1 participant is enrolled in GED classes at NWTC, and another is registered to begin those after her treatment group concludes. 1 is enrolled through a full scholarship to start NWTC's nursing assistant class, and is also registered for the fall semester's licensed practical nursing program full-time. 4 are single parents who are currently in the process of regaining full custody of their children. 1 is a single parent who has full custody of her child, and she's meeting the requirements of drug court while managing as a single parent. And then 2 participants have developed a local weekly Narcotics Anonymous meeting after seeing the need in Shawano for more recovery support group meetings. So that is just an overview of the program, some of the successes, and a couple of concerns that we have.
Okay. We got the light. Teresa.
Hi Becky, I have a couple questions after all of the information that you gave us, and I appreciate all of the information, but I have a couple questions. If you were given the approval by the county board in August of 2017, why did it take until 2018 October, 10 months later, to get the program moving?
Because that approval was just to begin forming the program, and then so over the next year, there was a committee, like a task force that worked to build the program, build all the policy and procedures related to it, attend trainings, multiple weeks of training in, I can't remember, out of state, Idaho, I believe, where they went and trained with another drug court team that's like nationally known, and then also just multiple trainings with the National Drug Court Institute and the National Association of Drug Court Professionals, so that they could ensure that our program is following the best practice standards that are set in order to get the best outcome.
Okay, and we were advised that on September 1st, 2020, you had your first graduate, so we're almost 2 years into the program before you have a successful person. My question is, how long does the program take to get a graduate from it?
So it's built, originally it was built being an 18-month minimum for the program. However, we reviewed in the last year the best practices and reduced that to a minimum of 14 months, but they have anywhere from 14 to 24 months to complete the program. When people enter the drug court program, they're not, they're actively using drugs most of the time. And so it takes a lot of time and effort and treatment for them to get to the point where they're actually meeting the benchmarks that they need to phase up. There's 5 phases in the drug court program, and they have to go through each phase. There's a minimum number of days in the phase, a minimum number of requirements that they have to meet for each phase, and then also we test them for UA drug testing at least twice per week, if not more, throughout the program, which is also funded by the TAP grant. If they have any slips or relapses, people sometimes have to go to residential treatment, or it may set them back in their progress going through the program. And so we often see that, especially in the first 2 phases, they're just starting to be able to stay sober and follow the requirements. But then as they get to like the 3rd, 4th, and 5th phase, they're becoming like active members, not only with their treatment, but they're getting employed, they're going to school, they're getting their GED, which they didn't have because some of them started using at 15 or younger and have been actively using drugs since then, so.
Okay, and you also said that you did training in Idaho. I think it would have been more cost effective to go to Brown County and
I believe that was
mentor them.
paid for by the National Drug Court Institute. They pay for all that training, and they pay for the travel and everything.
But what works in Idaho doesn't necessarily mean it works in Wisconsin.
Well, the standards that our program is based on is national standards, not on state by state or local standards. It's an evidence-based program nationally, so.
And we did, if I could say something.
I wasn't here during that.
Yeah, sorry, Becky wasn't our first coordinator. So we did travel to Brown County, Marinette County, Manitowoc County, Portage County, Brown County on multiple occasions. So we did visit many other local courts as well as during the process of creating our policy and procedure manual, we thoroughly reviewed what other Wisconsin programs are doing.
Could you state your name, please?
Jennifer Frost.
Sorry, I wasn't here during the development of the program, so thank you, Jen.
Thank you.
Okay, is that it, Tess?
Yeah, let someone else talk.
Okay, Marvin, do you have a question?
Two. One, you stated a whole lot of numbers that went over my head. What I want to know right now is, according to your latest numbers, how many are actually enrolled? And secondly, you mentioned something earlier in your report, the lack of referrals to the program. Who does that refer?
So referrals can come from numerous resources. The district attorney's office, the public defender's office, defense attorneys outside of the public defender's office, law enforcement, the Department of Human Services, family, people can self-refer themselves, various sources. But when a referral comes in, the way that our program policy is set is that before I can start the process of treating it as a referral, it has to be approved by the district attorney's office and law enforcement, which is different than most counties in the state because usually the referral would come in to me. The district attorney and law enforcement would complete the legal screen at the same time as the coordinator and treatment provider complete the risk and need assessment that's determining them to be appropriate for the program in that aspect. And then also that they have a moderate to severe substance use disorder that needs to be treated through drug treatment court. Our program has currently 8 active participants with a 9th one that was referred by probation that will hopefully be enrolling by next Tuesday. So 9, hopefully.
Kathy Lupke.
Okay, if I remember right, we were one of the last counties not to have a court.
One of 7
One of
in the
7.
state. Mhm.
Okay, here we're what, 2 or 3 years into the program. We have a chance of losing our grant money. Is there any other counties that have this same problem? Or is this a unique problem at Shawano County?
Well, when I spoke with the project manager, the program manager with the Department of Justice this morning, our program has just a lack of referrals coming in that's different than many other programs.
So it's something unique to Shawano County that needs to be addressed.
There was one other county that ran it the same way as Shawano County does, that's Walworth County, and with kind of the DA being the person that says yes or no, they can be screened. And that's the only county that they said runs it that way, or has run it that way.
Okay, so I just think some people need to get on board on this, so thank you.
Okay, Aaron Damrow.
So I guess what you're saying is the DA is the gatekeeper to the drug court right now, whether, I mean, that's the kind of gist of it.
So we can get referrals Probation can refer people as alternatives to revocation, and that process doesn't have to be approved by like the DA's office in regards to whether we can screen them or not. The whole team does still decide on ATRs whether they're going to be enrolled into the program, but for people that have new cases or new charges, that is how I get my referrals currently. That's how I got the 8 of the 13 referrals came from legal counsel.
So drug court it's like a team-based court, and you have the treatment provider, you have law enforcement, you have the DA, you have the public defender's office, you have the Department of Corrections. You have a lot of people involved that are making decisions on how to operate the drug court, right? And I mean, in talking with the drug court down in Lopaka County, it sounds like somebody, if they have a candidate, the DA does not get veto power on saying that no, that person cannot be screened. It's whether or not the participant, the offender is a high risk, high need individual. And I mean, the screening that they do down there is, I mean, if you're statutorily ineligible for drug court based on a prior sex offense, then you can't get in. But that should be the only legal reason that somebody should not be allowed to be screened for drug court. Is that the best standards for operating a drug court?
The way that they do it here, or Wapaka County? Is that
I mean,
the best standard is like what I had explained. Best practice standard is that we don't exclude anybody that, well, for our grant purposes, we're not allowed to have anyone that has a violent felony or misdemeanor, like a current felony or misdemeanor offense that they're waiting to get charged with. And then, yeah, I mean, otherwise what's supposed to happen is that we do screen everybody, especially in regards to the whole equity and inclusion thing. We're not supposed to be subjective, like saying, oh, well, so-and-so did this, so I don't think he's gonna do well in drug court. We're supposed to be objective and focus it on the assessments that are actually done to know if they have the high risk for recidivism, the high need for treatment.
And this is what is happening all across the United States, is to make these courts successful, is they're following the stuff that, I mean, you're looking at assessments, and I mean, following these practices, you're not looking, I mean, I don't think this person should be in drug court, or it isn't a personal opinion, it's science.
It's objective, yeah, and yeah, that's best practice standard is that high risk, high need offenders are brought into the program and they're screened through eligibility screenings.
So as a first-time offender, for, let's say somebody gets picked up for methamphetamine for the first time, their first felony offense, maybe they had a prior misdemeanor, like prior THC. I mean, a first-time offender, first-time felony drug offender, are they an appropriate candidate for drug court, typically?
It depends on the screening. The risk screening it's the screening that the Department of Corrections uses, that we use. Go ahead. Heather is a probation agent on our team, so she might be able to talk more on that.
Let's see if this one, okay. I'm Heather Hagling, I'm one of the drug court agents. I supervise Shawano and Menominee counties. I've been with the program basically since it started like 10. So the risk assessment that's being used for the people being put into the program is the COMPASS risk assessment. And for somebody like what you're talking about, most likely will not be high enough risk on that assessment to be placed as high risk, high need. And they look at number of arrests, they look at if there's a violent, if one of the offenses is violent, which we can't put them in the program already. They look at if domestic violence is involved, you know, stuff like that is some of the like static information. So those people alone, most likely, now it's not all of them, but most likely will not be appropriate per that assessment alone. That's not saying they may not have like a substance abuse diagnosis, but and we've had some of them where unfortunately I think the last one I was put in the program, when she was first assessed, that's what happened, was she wasn't high risk, high need. Unfortunately, she got more offenses, which then she was reassessed, and she was then appropriate for the program. So then that's how she got put into it. So there's multiple assessments being done, mental health assessments are being done, and that's how we get a lot of these people eligible. For Department of Corrections, we use it all the time for ATR, for alternative revocations, because right now they're trying to minimize the amount of people we're sending back to prison, obviously, and we're using more community-based treatment, so why not use this stuff here? I know as a Menominee County agent as well, that we have a lot of people going back and forth, so we do have the ability to waive the resident stuff if we're able, but that's a big struggle. I know there's a lot of people who have Kashina addresses that are having issues in the court system, but they're not technically eligible. So that might be something that we can maybe talk about. Is it appropriate for a waiver? Is it not? You know, stuff like that, because there's a lot of people there that need help.
So Menominee County residents aren't eligible for Shawano?
Because it's a Shawano County Drug Treatment Court program.
But
So-
it's the Shawano Menominee District Attorney, Shawano Menominee.
Well, I agree with you. I completely agree with you. But
And
yes.
Menominee County's funding the court system here.
So that is basically a talk that's been talked about for 2 years, that how do we get that on board, like everybody on board? And that's way above me. I'm not sure how that happens.
Okay. Well, we have 2 more people wishing to speak, but we're gonna have to keep moving along because there's other people that want to make some comments, too, and we're not gonna solve the issue here today all the way. Gene, real quick, please.
Yes, one thing, if we're on the brink of losing our money, what are the reasons they're giving you that you're gonna lose the money? So that you can work on those things and gain their support. If you're doing a lot of other things that is not taking care of the problem, you're still gonna lose. You've gotta go after the problem. And you're not doing it don't look like.
Yeah, the information that I've gathered from the grant manager is that we need to increase our referral numbers that we put into a database, so they see we're actually looking at people and screening the people for this program. Not all referrals are gonna make it in. They have to meet the eligibility requirements and the team consensus to let the person in. But so referral numbers need to increase, admissions into the program need to increase, and then the proper kinds of admissions need to happen. They monitor all of this by information that I put into a database through the grant system. So they're constantly monitoring how our program is doing, and they've already earmarked our program.
Okay. Deb Nofke.
Okay, I'm confused here. The first time offender that's obviously got a problem but finally screwed up big enough to actually end up being charged with something, that person you won't help?
That person may be able to they're considered lower risk most likely, and they may be able to get their help through a less intense program, a less expensive program, such as probation.
If we've got grant dollars just about to go away and we're not utilizing them, why wouldn't you try to stop a recidivism cycle, even if you see somebody that's just entering it? And
Because that doesn't meet the high risk, high need requirements that are required by our grant.
And the state does review them, correct?
Yes, they review it quarterly when I submit my reports, and our DHS finance office submits their financial reports as well.
okay, why are we one of the few counties that has somebody that has veto power, or for lack of better terms, that sounds like what it is. Why do we have, how's the DA supposed to know if a person qualifies for this? I mean, really, maybe law enforcement could figure it out if they're picking up the same person time and time and time again and they're always out of it. But why are we going through that procedure?
I don't have an answer for that.
Well,
Well, somebody's got to.
that's the reason we're here today, Deb. To get started towards an answer.
Well, maybe
Okay.
we should just change that. And why in the world wouldn't
Well-
we partner with Menominee County? It's Menominee County, Shawano Menominee County court system. We share the courts, we share the jail.
There's lots of things that have to be answered to correct this.
But
Let's,
we've done it with the buses, White Lightning and Blue Streak. We were able to leverage our grant money, and the tribe was able to leverage some extra. We did it with the health department. Why would you?
So it would have
It's
to be
just not
agreed
right.
upon by the counties, but it has been done where counties that do have a treatment court program, serve counties that don't. But it's gotta be an agreement between the counties, and that would have to be looked into a lot deeper on what.
Menominee
it all
County might
entails.
be able to get some grant funding too, especially if they're gonna partner with us. I don't see why we wouldn't try to do that. It's just like a no-brainer.
I can speak.
well, we're gonna move along because we have two other individuals that are involved in this. And I would like them to have a chance to speak so we can all hear their side. And then I'll give you my suggestion so far of what I learned with all of this. Would you like to come up, Mr. Kissel?
Oh, sure. Good afternoon, everyone. My name is, I'm Judge William F. Kissel, and I'm the Branch 2 Judge for Shawano Menominee Circuit Court. And I'm also the Drug Court Judge. And to give you just a little history, some of you may know me because a number of years ago, I was one of the presenters when there was the interest of having a drug court. And one of the reasons that I was invited to speak to the committee or to the board is because I was prosecutor for a number of years up north on the Menominee Reservation at a couple of different times, and I was the drug court prosecutor. So I had experience in drug courts for a number of years, and we ran a drug court up north for a number of years. It was funded through a grant as well, but it was funded through a federal grant. So I had that experience, and we were able to see how the treatment works, and how some of the advantages of drug court, some of the problems that can exist. So a number of years ago, we started this drug court. If I recall right, it was the presentation, I think originally came from perhaps Data Care had some interest, Social Services had some interest, and I know I was invited and the prosecutor was invited, and a judge from Marinette County made a presentation, and he presented his experiences with drug court. And at that time, the county then decided to set forth some funding to start a drug court. When we had that funding, we sat and I was the drug court judge and volunteered to do that. And we set forth to set up our parameters and our policies, and we met on a weekly basis with a number of the team members, including not only myself, but representation of the Public Defender's Office, law enforcement, probation, parole, the prosecutor's office, and of course our drug court coordinators. And after a long period of time, we set forth our policies and our procedures, how drug court would work. And I recall that we were cognizant, we tried to always bring forth best practices. And what best practices means those are not requirements, but it is what the experts say, this is what works. This is what you should do. And best practices are used on a variety of different type of programs. And I've always thought that it's a good idea to follow best practices because someone has already done the thinking for us and says this works. So we did bring forth those practices into our policies. And one of the things I think that I will say that there's always some confusion of, who's drug court right for? Who goes into it? Let me explain. And even outside of drug courts, the training we've had as judges, not even my training I've had as a drug court prosecutor, but as a judge. The training we have, anytime we have an individual come forward to us, perhaps in a criminal matter or otherwise, and we're maybe placing someone on probation and setting forth certain things they need, one of the things that we are told is when you're giving any type of help or treatment in any type of thing, mental health, drugs, alcohol, violence, whatever there is, you have to use the right amount of medicine for the right amount of problem. In other words, just like a doctor, they don't give you strong medicine for something that is not a need for strong need. The reason is, and we are told a couple of reasons. One, if you have a person who does not have a real big problem, don't give them real big treatment. Because number one, it won't make them better, it'll make them worse. The other problem is, it obviously doesn't make any sense, and it just isn't very cost effective. But the main reason that you can make someone worse rather than better. Now that relates also to drug use and drug abuse. So one of the things you've heard Ms. Egren indicate, and I think we've also heard Jennifer Frost mention too, is what is right for drug courts and the best practices as you hear the term high risk, high need. What does that mean? Well, high risk. Someone who has a long history of drug problems and is very much at risk of continuing to use these drugs and they're addicted, and they're going to have very, very bad consequences. High need is they have great need for help and treatment, and for the time that is there. So sometimes we look at it, and we all think, and as our gut feeling tells us, we just stop that person with that joint in the car, we stop them with a marijuana cigarette. Aren't those the kind of people we need to get there to stop them from their drug use? Well, I think it's always good to become involved with individuals and try to help individuals who are starting off in a problem, because it makes good sense. But the question is, what type of help do they need? So if the question, are they a high risk or high need? And most likely they're not. But they may need some help. And one of the things that happens, so if you typically have someone who is a first-time offender or doesn't have a long history and they do have some possession of drugs, what the options are of the court is many times they're placed on probation and they're required to follow certain requirements such as an AOD assessment followed through a treatment. Now some of those individuals may not do well in treatment and through probation, and maybe sometimes they fail and they're at risk of being revoked from probation. Sometimes those people later we find do have a higher risk because they have failed. But I want to make it very clear that the best practice is high risk, high need. These are people who need our time and our effort. Be aware that drug court is very time consuming. It's very, very expensive. So you want to make sure, and it's not only expensive and time consuming for the county and the people who work around it, it's also time consuming and difficult for the individuals who are admitted into drug court. Drug court is not a free ride. It's difficult. The people who go into drug court, their lives are controlled by that drug court team. They're told where they can live, pretty much. They can tell, they're told the jobs they can have, can they be employed, their hours of employment, who they can talk to, who their friends are, what they can do, what they can't do. They have to go to multiple meetings, multiple type of sessions that they have to go to. Not alone, they have to meet with the drug court judge on a bi-weekly basis every 2 weeks, and we go through, they have to appear in court. So there's a big investment that they have to. So this is why it's important to understand high risk, high need. These are for people who really need our help. So there's that issue. Now, I'm committed to the best practices. I think that's important. Now, there might be some concern from the people here. But what about those other individuals who may have a need, but they don't meet the drug court? Like I said, there's other options for them. One of the other options is a probationary term, and they can be sent to various treatment as a condition of probation. There's other things that the prosecution can do. They have other abilities to do things, and I won't speak for the prosecutor. They can perhaps discuss some of their other options that they have. Now, I hear about, and I don't really take a position on referrals, except that referrals need to come in. They have to come in. That's how the process goes. Look at some of the communities. I think every community I think is unique and different. The question we ask is, do we have a drug problem here? Do we have people with high risk, high needs? Of course we do. Every community does. Do we always see those in court? Not necessarily. I know that in some communities they have, maybe in the cities, you'll see an individual come time and time and time in front of that judge, a judge who sees them time and time again for felony possessions of methamphetamine and heroin. At some point, they're no longer going to be sitting in a jail for 9 months. At some point, they're not going to be sent to probation. They're going to go into prison. And prison for a lot of that is a lot of times a long period. Now, the training we've had from drug court people, we've had training right here in Shawano County. We had it at the new building, the new social service building, and I think it was more than 1 day. And one of the things that has been told to us, and it's been told to us, high risk, high needs, and they have to have a high risk and high need, and they have to hold something over their head. The best practice is usually 1.5 years in prison, followed by 2 years of extended supervision, and that is imposed and stayed, which means if they fail, that's what's going to happen to them. Now, we just can't take an individual that is someone you put in jail for a year and say, because we're going to put you in drug court, we're going to impose and stay that kind of a sentence, because that wouldn't be right. That's not ethical, it's not right. So you've got to have people who truly are that far gone, that they're looking at those type of factors. So that's some of the issues that I think that pop up. When it comes to, I will say one thing that I see is a need that I have, because I think we all have needs. Tools that we need. I know when I worked up north on the drug court program, we looked in, when it was negotiated, we made sure that all the invested parties are able to have the tools they need, which included both the courts, the prosecution, the judges. So when we had that fund, we made sure that there was funding for the help that we need and so on. The commitment I had, and I said I think we can, with what we have, is be able to get 12 people through, 12 people at any one time. That's reasonable with our time period. I know we're looking at up to 20. That is going to be difficult for the court to do with time because we just don't have that time. We can't calendar that much time. I have actually doubled the amount of drug court time at the beginning of the year. But there is a solution. And I'm not asking for action on this, but I said it before and I'll say it again. We have a part-time family court commissioner. That is part of one of the people we have here. And court commissioners handle a number of different things. They handle some of the areas where there are, before you're getting divorced, they're meeting with and taking care of some family matters, some temporary hearings. They do these various things. Most counties have a full-time court commissioner, and that court commissioner has the same duties, but can handle things like small claims, uncontested divorces, restraining orders. With a full-time court commissioner, that would grant and give this court much more time where we could then handle much more people. We could handle those 20 people, I think, easily with a full-time court commissioner. That's one of my stumbling blocks right now. We're not at the maximum that I can handle right now. It looks like we're at somewhere 9. We still can get a few more with our calendar. But 20 would be not really practical at this point. And I want to explain why that is, because this takes a lot of time. our court calendars are very congested, and when we have to schedule things, we're scheduling very, very, very far out. We don't want to be, people have to have divorces, we don't want to schedule those out 6 months, 8 months, 9 months out, because they have a right to use our court systems as well. So I think to make this program successful, and over the years in the grants that I've had to be responsible for as a prosecutor, we always put in our statements to our grant individuals what our stumbling blocks are or what our needs. So I will tell you the need that I have right now is a full-time court commissioner if we're going to expand this program. We need to have buy-in, and I think that everyone needs to buy in, and I think there's a responsibility at this point to look at that. And I heard Ms. Egren, who gave a lot of facts and figures today, and said that, you know, we probably saved, it sounds like a few $100,000 in jail time. If those are actual savings, I think it justifies some of the money that we might need to spend to bring forth a full-time commissioner. And so we can expand this program. If we can expand it to 20, then I'm hearing it's saving over $400,000. I think that would be a good use of the money. Like I said, I'm committed to this program. If I can have the commitment, I think, of the county in this, as well as the other parties. That's how I see this program. I will say that one of the things, when most of you hear what Becky has said, of the people we've had and the failures we've had, the people who are terminated from a program, first of all, let me make it very clear, the terminations we have are not unusual. That's normal. People who have drug problems, it's a very, very difficult thing to solve, even with the best intentions. Obviously, the prognosis is not always as great as it could be. It's very important. One of the things this program can do, and hopefully as this program takes off more and more, we need to have community education, and this program can work to educate the community. I have found over the years, at least when I was doing it up north, sometimes that education doesn't come necessarily from a TV ad or a pamphlet, but it comes from the people who are in that program themselves. Sometimes you'll have individuals who they go through that program and they have an enlightenment. They realize that they went through this pain of going through this program and getting off these drugs. They become spokesmen for us, and they tell their other friends that this isn't the way to go. But that's my take on this at this point, and that's my comments.
Okay, thank you, Your Honor. We have one other interested party in the program, and that would be Mr. Parker. Would you like to speak, or someone from your office that is in on the drug program? Drug court, I should say. And like I said, we're not going to solve this today, but it was requested by a county board member to do this, so
So
we have to do it. Right?
Good afternoon. First, I'm going to introduce you to Assistant District Attorney Laura Nelson. She has been taking care of the drug court since November of 2019. So I'm going to let her make comments because she's been the most involved with it for that period of time. And then we can make some, then I'll make some comments as well. Also, I'm going to be walking by as she's talking to just give you a couple of emails that I had very early in the program of concerns about the drug court itself and what we needed to do. So, so you'll have that. You don't have to read it now. It'll be borne out basically in our discussion.
So good afternoon. Like Greg said, I'm Assistant District Attorney Laura Nelson. I've been with the program since November of 2019 when I started as an assistant district attorney. Before that, I was a defense attorney. I took a lot of cases around northeast Wisconsin, including Marinette, and I had several clients admitted to that drug court program, and I can tell you that for a district attorney to have veto power over admissions into the drug court program, Deshae Morrow, who is the district attorney up in Marinette County, she had final say before the participant was ultimately referred to the team. She interviewed the person, spoke at length with me at least, and she, before a referral went to the team, she had final say. So she actually made that final referral to the team before this, and made the screening referral. So it's not unusual the way that Shawano County handles this. And Marinette County is one example. Shawano County is following suit. So I also want to talk a little bit about the referral process. I want to talk at great length about the referral process because there seems to be some disconnect in regard to what can and cannot happen. First of all, we cannot have anyone from DHS or from the treatment team going to speak with an unrepresented defendant while they are in custody or even out of custody if they have asked for an attorney to represent them. If that is the case, then the district attorney's office, whether you agree with it or not, will be sending a subpoena to that treatment provider or to Becky, for example, if she goes to screen that defendant or potential participant. We'll be sending a subpoena to her for her to testify for any communication that was revealed during that screening process, because those communications are not privileged. As you may be aware, there are certain communications that are privileged: doctor-patient privileged, lawyer-client communications are privileged, and pastor or priest and penitent communications are privileged, but not Becky's screening interview with a potential drug court participant. That is not privileged. So if she, prior to a defendant or a participant having that attorney on board, if she goes to screen that person, that is not a privileged communication. And to the extent that that person makes an admission of having drugs in the vehicle or drugs on his person, or that she any other fathomable admission, we are going to get that through the subpoena process. So I just want to make sure that everyone understands the referral process and what is and what is not acceptable on the legal screening side of things. So not every law enforcement contact, first of all, or referral that comes to the district attorney's office turns into a prosecution. So it has to be in the system before it even becomes viable as a potential referral. So for example, and I know we see Lieutenant Leiser here, anytime one of his deputies or an officer with the police department has a contact, that's not necessarily going to turn into a prosecution. We may no cross it for whatever reason. Maybe we don't think we have the burden, we can meet the burden of proof for whatever reason. And then, of course, not every prosecution on our side is going to go out to a defense attorney for an offer for drug court. And that might be one of several reasons. One, if that person may not have a Shawano County residence, which we see a lot of. And I know Heather spoke briefly about that, and that's been an ongoing struggle for us. Highway 29 is a major corridor. We see a lot of people coming and going from Shawano County. We know that we have a lot of enjoyable lakes here. People come up here for a lot of recreational activities, and unfortunately, they bring drugs with them. Either the state troopers or Shawano County deputies or the police department are stopping a lot of people and they're finding drugs. But not all of those people are Shawano County residents. And that's one of our struggles. We can charge them here because this is where the crime happened, but we don't necessarily get all of those people as eligible for drug court because they're not residents here of Shawano County. Second of all, they have to meet the legal qualifications, and that doesn't necessarily mean that everyone charged with a drug crime meets the minimum requirements. So, like we were saying, everyone charged with a possession of THC or even a first offense possession of cocaine, which is a misdemeanor, which may be shocking to some of you. We're not going to get those people who we can impose and stay a prison sentence with the required extended supervision. And that's what's required. We're going to need to have some stick to hang over their head in order to make this work, because we need a minimum of 2 years of probation in order to get them through this program. There was a very good question earlier about how long is this program? How long does it take to get them through? They need to be on probation for a minimum of 2 years according to the policies and procedures that were defined by the drug court team. So they can't be on probation for simply 1 year, which is what we get for a possession of THC. Nor can we just impose and stay 9 months for a first offense THC. These are not kids who are caught smoking weed in the basement. That's not who we're targeting. And that's not by my definition, that was the drug court team. That was DHS with the high risk, high need. That's who they targeted. Okay. So it would be unethical for us to target that population. We also can't go to the other end of the spectrum and target the dealers, the traffickers, the manufacturers. We can't put those people in drug court. We can't give them their built-in buyer's base. We have those people here in Shawano County, but those people have a place to go, and that's called prison, okay? Those people are not going to go into our drug court. We're not going to put our participants, who we do want to help, we're not going to put those people at risk. All right, so we have the two ends of the spectrum. We need to find the middle ground. We still have to weed them out. We have, at the district attorney's office, we still have to see who else are eligible. We still have to weed through who's a resident of Shawano County. By looking at their record, we also cannot take in violent offenders, okay? So we have to look at their past convictions. We have to look at, we're not taking in OWIs, we're not in OWI court. Okay, so if they are caught with OWI offenses or operating with a restricted controlled substance, we're not taking those people. We're not going to put the people of Shawano County, the citizens of Shawano County at risk with people who are going to go out on the road and drive while they're intoxicated or with restricted controlled substances in their system. Obviously, homicides. If they were convicted of homicide in the past, we're not taking those people. Any violent offender, and there's a definition of who a violent offender is. Kidnapping, if they were convicted of kidnapping. Criminal vehicular homicide, sex offenders. Anyone who committed a crime to benefit a gang. Now, these are all listed in the policies and procedures. So if they have that history in their conviction past, we are not going to take those people. And that's the screening process that the district attorney's office does. Okay? So it's not as simple as taking a look at their, at whether they have a repeated meth history or a repeated heroin history and saying, well, yes, we need to send them over as a referral. The next thing that we take a look at then, assuming that the initial screening is done, and once they get a defense attorney on board, which can take a long time. And it's not just Shawano County that struggles with that. That's statewide, okay? In a recent case ruling that came out of the Court of Appeals, State versus Naomi, the State Public Defender's Office issued a letter in there saying we have a statewide problem appointing attorneys. It's not limited to Marathon County. So this is a statewide issue. It is a Marathon County case, by the way. So now we have a communication, we can communicate an offer saying, hey, the district attorney's office, we've screened it with the law enforcement. Law enforcement has taken a look at this, and the law enforcement is okay with making an offer to the to the defense attorney if you want to extend a drug court offer. Now the defense attorney can talk to his or her client and say, do you want to participate in drug court? We can do a drug court offer. Now it's up to the defense attorney to say to his or her client, let's talk about drug court. Now you have one of three paths to go. And as a former defense attorney, I can tell you how this conversation is going to go. The defendant knows what jail time looks like, or prison time. Chances are they've been there. They've sat some time, they know what jail is all about. They know what a straight jail term looks like. They also know their chances of facing a straight jail time sentence looks like, based on whatever their offense is, okay? They also know what probation looks like. They know how hard probation is, they know how expensive probation is. They can weigh their options there. And if the defense attorney is doing their job, they're gonna tell them exactly how hard treatment court is. Okay, and I've had this conversation. I've told them, probation starts out really tough. They're in your face, they're in your life. You behave yourself, eventually they're gonna back off a little bit. Okay, you might start off high risk, and then you're gonna back off, and eventually, if you behave and you don't violate, then maybe you'll go to once a month, phone calls, house visits, things like that. They know this. They're used to the system. We know of defense attorneys who have said, don't even go down the road of treatment court. Don't go there. Ultimately, it has to be the participant, the defendant, who says, yes, I want to participate in this. And I can tell you for a fact, we have multiple offers out to defense attorneys right now that we're waiting to hear back from. It's the conversation with the defense attorney and the defendant that bring it back to us, and they say, yes, we'll take a drug court offer. That's when the defense attorney contacts DHS, Becky, and we proceed then with the screening. Because then the conversation is privileged. We go ahead and we set the plea and sentencing date. There's one right now set for April. Apparently, according to my conversation with Becky, it's kind of iffy whether the drug court even wants them. But we'll have more discussions. We'll get her in. In any event, it's not a simple, there's a defendant charged with drugs, let's get that person screened in and that person is accepted. It's a multi-layer process that everyone has to appreciate and be patient with, because the legal system isn't like CSI or Ally McBeal or LA Law. It doesn't happen that way. So, with that in mind, anyone have any questions?
I would like to avoid the questions. We've been at this for an hour and a half, and we're not going to solve the problem here today. If you would like to take a few minutes, Greg, and say your piece.
One of the things that I heard here today, and this subject has only briefly been broached in the beginning of the program, and that was whether or not we could take people from Menominee County. The problem with that I understand is because of the jurisdictional aspect. It's a sovereign nation. So that somehow would have to be worked out. And yes, as Ms. Haflinger had mentioned, we have a lot of cases that come from not only Menominee County, but other counties as well. But if Menominee County was able to be included, that would give the base, that would give our base more possible referrals. But it's the jurisdictional aspect, the fact that they said they're a sovereign nation, and if that's the case, it may not even be able to be done. But but we shouldn't do a discussion about it. We should do a discussion about it. And perhaps that can be taken up soon. But we've never had that discussion. It was just determined in the beginning it would be Shawano County residents, and that's it. Secondly, as Laura was saying, there are multiple people out there that have been asked about drug court, but here, we all sit here with our masks on. We don't escape COVID, even in the criminal justice system. And I'm sure you're aware of that. We are now 354, as of the beginning of March, I believe it is. We'll be 354 if the witness person's calculations are correct. 354 adjourned trials, meaning jury trials that have been scheduled or are going to be scheduled, and at this point in time, we can't even have a trial yet. There's only tentative approval as far as I know. But what the defendants have figured out, though, if they're out on bond, one of the things they can do is to delay their case, is to ask their lawyer, I want a jury trial. And it gets kicked way out. And we are having trials that are being scheduled. For example, the other day I was in court in October, 8 deep. 8 deep. So this isn't the simple solution. But as far as getting more referrals in, we have to light the fire under hopefully some of the defense attorneys. This is another issue. I told my prosecutors, if you have somebody for drug court, let the defense attorney know. 2 of our prosecutors have left. One retired in January, early January, the other one left in the area, or in around about 3rd week of December. We've replaced that one person. We still have another to go. So now, what I hadn't had the opportunity before is now I'm able to see the one retired prosecutor's cases and start reviewing them, because I have to reassign them to somebody else. And in that vein, I'm able to see if we have people that should have been or will be also referred for drug court. So those are my comments. I decided to keep it short. Thank you.
Okay. Basically, I sat down and I talked with all the interested parties, and them are the answers that I did get from them. The district attorney feels that there's not enough people that qualify to fill what would be there to get the numbers up, so we would meet the state grant. And the judge feels that they just do not have the time, and that would require us to step forward and provide more funding as a board. And Health and Human Services would like to see the program stay and keep operating. I would too, because I think if you can get anybody out of that cycle, but it's not as easy as we think sitting here and your first opinion that, well, if somebody comes in, we can run them in there because there's so many restrictions and requirements that have to be done. So all I was going to suggest with this is we certainly can't solve it here today, but we can start looking into it a little more. And I believe the 2 committees, just to start it, would be public safety, because that's who the district attorney and the judge, I believe, are under, and the Department of Health and Human Services, and that may require some joint meetings and some discussions. Perhaps we could get Menominee County. I was not aware that they were eligible. I didn't learn that in the past discussions. And I'll put Jimmy on that to start looking into how and if we could merge between the two counties. We just taking notes. And start looking into this, if we can join with them to possibly get more funding and more people to where the state wouldn't say you're not trying hard enough. But it's not an easy solution at all. And if anybody has any ideas, bring them forward, send me emails, suggestions, anything you can come up with, because I don't have an answer for it either. Not at all. And we have to work on it though, or losing the funding, to me, I think it's good money spent. If you get anybody out of that cycle, they're not going round and round and round again. Right back into jail, right back into court, out on probation, because we're paying all them people for processing them in that service. And it's all very expensive items. So we will move on. Then we have quite a list of items to get through, and I promise you, I will never let the chairman's comments take us an hour and a half to get through again. Item